How's it going? My name's Robbie Dixon. I'm super excited to help out throughout this name, image, and likeness module of the special topics course in intercollegiate athletics. NIL is something that I'm studying pretty much daily, keeping up with the new laws and trends and the different cases that are making their way through the court system right now. Um, it's very exciting. It's a very exciting time to be a part of NIL and watch NIL. I encourage everyone to kind of keep an eye out for it because there's a lot of cool stuff happening. Um, and yeah, definitely super excited to be here and be back working with Michigan State. So thanks to Dr. Driska and Dr. Kim for bringing me in to help out. A little bit about myself. I'm currently a third-year law student at the Catholic University of America in Washington, D.C. Before I came to Catholic, I got my master's from the SCLA program at Michigan State. I graduated in December of 2020. I have my undergraduate degree from Penn State. I swam there 2015 to 2019 and was lucky enough to be team captain during my junior and senior seasons. So I've been around sports and athletics my entire life. Don't ever plan to leave this world. I love it too much. It's done a lot for me and brought me in contact with a lot of amazing people. Um, but yeah, I guess we'll get right into this NIL stuff. What that's all about. So currently, and this kind of ties into two of the readings that you guys have taken a look at, the monopsony power reading as well as the House versus the NCAA case. So we'll start with the monopsony power one. On October 5th, actually, the Dartmouth men's basketball team, there was a hearing for both the school and the men's basketball attorneys. They took part in arguing on whether these athletes, the basketball team, should be able to unionize and whether they can be classified as employees. That's pretty similar to what you guys read in the monopsony power reading, talking about the Northwestern football team in 2014 and how they fought to be able to be a union and whether they met the definition of employees. And back in the 2014, the NLRB said, yeah, they met the definition of employees, but that they weren't going to permit them to unionize. And so it's going to be interesting to see if anything changes, 9 years later, especially with some of the big Supreme Court cases that have happened since then and kind of the implication of those. Me personally, I think it's only a matter of time before the athletes are going to be considered employees and they're going to be able to negotiate directly with these schools, with their schools, for salaries and for rights and other things that professors and other people that work for universities, they get. I think the big thing is going to be this TV money that's out there, hundreds of billions of dollars that are negotiated because of the marketability, and because people want to tune in and watch the players, and that kind of drives up the bargain that these conferences get when they're selling these TV rights. And I think it's, like I said, it's only a matter of time before the athletes are able to capitalize off of that. And I think they deserve it. I think that they more than deserve it. I think NIL is such a small part of what these athletes deserve, and it's almost like the NCAA is just kind of throwing them a bone, right? Just so they can hold on to the TV money for as long as they possibly can. So that's the first thing, is the unionization and whether these athletes can be called employees. Second thing dealt with the Sports Illustrated article on House versus the NCAA. And so, like the reading kind of says, this was led by Grant House, former collegiate swimmer at Arizona State, now a professional swimmer at Arizona State with a pretty good shot to make the Olympic team next summer, which would be great, right? Pretty cool experience for him. He's also suing the NCAA for $1.4 billion. So I don't know if he would, want the Olympics more or a little bit of that $1.4 billion, but him and a bunch of other athletes are suing the NCAA for back pay. So since Alston went into effect in 2021 and the state laws permitted athletes to compensate or receive compensation for their name, image, and likeness, now during this House NCAA case, they want to go back to 2016 and they're seeking NIL back pay. So the money that they missed out on because the NCAA and state law didn't permit athletes from receiving compensation from their name, image, and likeness. So those are two probably of the biggest trends that are happening right now in regards to NIL. I mean, when you look at all of these readings, they're basically designed to give you a quick and educated crash course on name, image, and likeness. I think that you could teach NIL in a whole course, and there are certain schools that are doing that. I personally would love to be involved in that, help teaching NIL, because you could spend a couple of weeks on O'Bannon, a couple of weeks on Alston. There's a lot of different ways that you can, break down name, image, and likeness and kind of talk about the trends and where we started to where we're going in the future. But when you're looking at some of these other readings, the NCAA's mishandling of student-athlete compensation, I think that 2020 article is a good place to start because it was written before anybody was able to compensate off of their NIL. So it talks a little bit about California passing or being the first state to pass a pay-to-play act where athletes were able to receive compensation. And I think it's pretty neat to see like what was written during that time before it was even permissible, basically what they were trying to forecast and what they were arguing for. So that's why that reading was first, kind of set the tone and get your minds thinking about different arguments and different possibilities there. We touched about the monopsony power article. Then the next article is the potential reach of O'Bannon versus the NCAA. This is a 2015 law review article from a 2015 case, I believe. The first big antitrust case regarding the NCAA. And it allowed the Division I schools to increase their scholarships to the full cost of attendance. So room and board, full scholarships, all of that stuff. And this was kind of the first domino to fall that kind of led us to Alston, which is the big case that led to states permitting or passing laws permitting athletes to receive compensation from their name, image, and likeness. So I don't think that we could have gotten to O'Bannon or could have gotten to Alston without first having O'Bannon. So a little bit of background. Ed O'Bannon, I believe he was a UCLA athlete. And I'm sure everyone knows the EA Sports, the college football games. What they were doing was they weren't exactly using Ed O'Bannon's name, but they used everything else, right? They used his physical characteristics, his number, and he didn't receive any money from this. And so he brought the suit against the NCAA for not allowing him to receive compensation for his NIL in the video game. And so that's another thing, taking us back to current trends, that you're kind of seeing with the EA Sports. They're bringing it back next summer, the college football game, and athletes being able to receive, I believe it's $500 for their rights or publicity rights in the game, their likeness in the game. And so that's a good article kind of touching on student-athlete compensation, unreasonable restraint of trade in violation of antitrust law. That O'Bannon article does a really nice job of setting that up, which kind of takes us into the big one. It takes us into the Harvard Law Review article on NCAA versus Alston. Groundbreaking Supreme Court decision in 2021, which kind of led to states, like I've said, passing laws that allow athletes to receive compensation for their NIL. And so I think the biggest misconception is that people think that Alston granted the ability or granted athletes the right to receive compensation for NIL, and that's not true. NIL is all state law based. The states have to permit athletes to receive compensation for their name, image, and likeness. And so this Harvard Law Review article talks a lot about the case and does a really good job in plain English of breaking down the court's opinion. And then you have amateur or professionals, NCAA, Alston, and the future of intercollegiate athletics. And so I think this is a super short article. It, again, gives some background on Alston, kind of what happened and some of the ramifications moving forward because of Alston. as well as it talks about some of the potential future legal issues resulting from Alston. And you're kind of seeing some of those with House v. NCAA, this Dartmouth matter, some antitrust. Like, there's always going to be an antitrust argument when it comes to the NCAA, just because, you know, they're really not interested in these athletes receiving adequate compensation for what they provide to their schools. And I know you could make the argument about education and amateurism and how it's going to ruin college sports if these athletes receive compensation, but I think you've seen what happens when these athletes have received some compensation. It's been almost 2 years, over 2 years since Alston. The NCAA is constantly breaking their viewership records. I mean, look at Deion Sanders in Colorado and the athletes that Travis Hunter and Shedeur Sanders receiving NIL deals and the viewership that's bringing. I mean, that Colorado program was 1-11 last year, and now they're breaking viewership records on ESPN. I mean, NIL played a big part in that. You look at, like I said, the women's basketball tournament, Angel Reese, Caitlin Clark. There's so many athletes that are benefiting from NIL, and they're doing good. I mean, you know, they donate their money back to their local communities. I think Caitlin Clark had a shoe drive, and she's having basketball camps, and there's so many good things that athletes are doing within their communities and college towns that wouldn't have been possible had they not been able to receive compensation from their NIL. And so I think it's something important to think about as you go through these readings is, yeah, while the NCAA, they want to protect amateurism, they want to protect their perfect, beautiful image and all of that, but think about, you know, and I'm sure some of you guys have been athletes or are current athletes, the time that you've put into your sport and how great it would be to be able to, you know, receive some profit for that, because you don't really have the time or ability to go, you know, have a job during college and stuff like that. So it's just something to keep an eye on and keep an open mind about, regardless of whatever side you fall, whether you're pro or against athlete compensation. I think all of these readings, like I said, they do a really nice job of giving you a crash course on NIL, giving you some good things to think about, some good food for thought. And yeah, we'll kind of move into the assignment now. So there's 2 questions that came to my mind after doing these readings and just thinking about NIL in general and how you guys might be seeing NIL on a day-to-day basis. So the first one is based on the readings as well as your interaction and experience. And if you have whatever your interaction and experience is, if you don't mind, you know, kind of talking about that throughout this first question, that'd be great. Whether it's a very limited experience or you just heard someone else's experience, that'd be great too. I'm just looking for different perspectives. I see things from the legal perspective now, as well as the athlete perspective. So if you're an administrator or a coach and you've got, you know, a completely different view of NIL, I'm all for it. I'm all ears. That's what this is all kind of about. I think that's what, you know, any graduate degree is all about, bringing people together from different backgrounds and, you know, allowing everyone to kind of bounce their ideas off of each other. So based on your readings as well as your interactions and experience, why do you believe that the NCAA continues to fight against adequately compensating the very athletes that help generate them millions each year? So I talked a little bit about these TV right deals and, you know, Caitlin Clark and the other athletes that, you know, they really do big numbers for the NCAA and their respective schools and conferences when you look at it. So why do you think that the NCAA continues to fight against adequate compensation for these athletes so hard? They're doing it right now in House versus the NCAA. They're doing it in the Dartmouth men's basketball case against unionization. Why do you think that is? Because they're not winning this fight in public appeal, you know? No one thinks that the NCAA is doing a good job or has a favorable, most people at least don't believe they have a favorable or don't have a favorable opinion of the NCAA. So why do you think that the NCAA is fighting so hard against athlete compensation? And I guess a little sub question to that, regardless of what side you're on, is what's your current stance on athletes receiving compensation for their NIL? Did any of these readings influence or change your opinion? So that's kind of the first question, big picture question. And then number 2, I guess is similar because in NIL everything's kind of tied together a little bit, is what do you believe led the Supreme Court in NCAA v. Alston to finally hold that the NCAA's rules limiting education-related benefits violated Section 1 of the Sherman Antitrust Act? Do you believe it was because of the public pressure and finally a changing of the times? Was it the unpersuasive arguments of the NCAA? Or do you believe that athletes just deserve to be compensated? So these questions, they kind of go hand in hand. The second one's more tailored to some of the cases, and I think Dr. Kim has the NCAA v. Alston actual case opinion if you want to take a look at it. It is pretty long, but I do recommend reading the concurrence from Justice Kavanaugh. It's a pretty scathing occurrence of the NCAA. And so I definitely recommend at least checking that out. But big picture, what I'm looking for and what I hope to accomplish is just stimulate some thought. Whether, like I said, whether you're pro or against athlete compensation, I'm pro athlete compensation, and I make that pretty obvious. I do like a good dialogue. I like conversation that challenges my thoughts, and I hope to, that some of these ratings challenge maybe your thoughts. And so no matter what, like I said, whatever aspect of the sport you're in, athlete, coach, administrator, I believe you're going to need a foundation in NIL. Just because it's not going away. It's only going to evolve, and there's only going to be more rules and regulations surrounding it. So just have fun with it. If you go off on a tangent on these questions, I'm okay with that too. Just want to see some good thought and some good effort put into this, because I think that you'll learn a lot. There's a lot of good stuff in here. I'm constantly learning about NIL, so I definitely recommend, keeping up with NIL on social media. There's a lot of good attorneys. Darren Heitner is a really good sports attorney. Mitt Winter. These guys do a really good job of covering NIL on a day-to-day basis. So I definitely recommend that. And then if you have any questions or thoughts even after this module ends on NIL, or you just want to talk about NIL, I think Dr. Kim will provide you with my phone number or email, and you just shoot me an email. But yeah, just have some fun with it, and if you have any questions, just let Dr. Kim and I know. I'm super excited again to help out through this module, and look forward to reading your guys' work.